Okay, this will be some jury charge at 120 words per minute for the record. Ladies and gentlemen of the jury, throughout these instructions that I am about to give you concerning the charges, I will more than likely use terms that have a specific legal meaning to them. I do not like to stop and define those terms every time I use them. So I am now going to give you the definition of some of the terminology that you will hear in the remainder of these instructions so that you have a clear idea what I am talking about. These definitions will apply throughout the rest of my instructions. They may also apply whenever these terms are used later on, unless the topic of the information being delivered to you has some other meaning that applies. Now, we don't expect you to get out your dictionaries and look up every term. If you have a problem with some term or the wording of a sentence or whatever, just let me know. The term false means untrue. Most statements or representations are false if they are untrue. But in the courtroom, a statement may also be false if it conceals another fact. According to Webster, false refers to anything that is not in essence that which it purports to be, and may or may not connote a deliberate deception. False means untruthful, lying, or being dishonest. False can also mean misleading, as to mislead in the presentation of facts. The term fraudulent is closely related to the term false. A statement or representation may be false or fraudulent when it constitutes what is known as a half-truth. A statement may be fraudulent if it attempts to conceal a material fact. Fraudulent acts are done with an intentional deception to cause a person to give up something. Fraudulent acts are done with deceit and trickery with the intention to cheat. Ladies and gentlemen of the jury, let me define the word intent. Intent means to act on purpose toward a specific result. Intent is shown by inference, action, or circumstance. Intent means firmly directed or fixed or in earnest pursuit toward a specific goal, object, or act. What does the term knowingly mean? Knowingly means that the act was done in a voluntary manner. The act was intentional. The act took place not because of some accident or mistake. The act was deliberate and intentional with full awareness of the possible outcome. The person knowingly performed the act. Ladies and gentlemen of the jury, what is a material fact? A fact is material if it has a natural tendency to influence a person or is capable of influencing a person to whom it is addressed. A material fact is important enough to affect the outcome of a case. A material fact is important enough to determine the validity of a legal instrument. Ladies and gentlemen of the jury, what does the term willfully mean? Willfully means that the act was committed on a voluntary basis. The act was done purposely with the specific intent to do something that the law forbids. The act was completed with the goal in mind of either disobeying the law or disregarding the law. Now, throughout the instructions, you will notice that we use the word and sometimes we use the word or. These are little words, but they can have a profound meaning on a sentence, on the testimony, and on the outcome of the trial. Both and or are considered conjunctions. They connect words, phrases, and clauses to give meaning to the sentence or the paragraph or the material that is presented. The word and means everything or everyone. If you say John and Mary and Susie using the connector and, you are saying everyone or everybody. John and Mary and Susie are connected by the word and given equal weight. If you said the rope and the knife and the gasoline using the connector and, this would mean all items are included. Now, ladies and gentlemen of the jury, the word or means one or the other, not all three. If you say John or Mary or Susie, what you are really saying is that one of them is involved. All three are not included when the word or is used. Well, I hope my vocabulary lesson will help you as you listen to the jury instructions. Thank you again, members of the jury, for your attention. Okay, this is some congressional practice for the record. Mr. President, I thank my distinguished colleague for his excellent statement. He has very eloquently stated the clear and present dangers with which this amendment is fraught. Mr. President, I thank the chair for momentarily indulging me. I have listened to the claims of the proponents of the constitutional amendment for several days now. I compliment them on their dedication to their cause as they see it. I respect their viewpoints. I respect their sincerity. I realize that not everyone will agree with my viewpoint. I commend the distinguished senator from Illinois, Mr. Simon, for his steadfast adherence to the belief that the way to get our deficits under control and lower the interest on the debt and reduce the debt is to adopt a constitutional amendment on the balanced budget. I respect his viewpoint. I differ with it, but we can differ as friends, and we do differ as friends. I also speak with respect to the distinguished senator from Utah, the chairman of the Senate Committee on the Judiciary, who is a very formidable and principled supporter of the proposal. I think they are wrong. They think I am wrong. But it is the people out there that we hope to try to persuade as to which viewpoint is the right one under the circumstances that obtain. So I have listened to the claims of the proponents of the constitutional amendment for several days now. As I listen, it seems to me that the proponents are selling this amendment very much as the old-time peddlers sold tonic and liniments, kidney pills, and snake oil. To hear the proponents tell it, this amendment will cure everything that is wrong with America today. Just take a good swig of this magic tonic, Mr. and Mrs. America, and your problems will disappear. Your head will stop aching. Your arthritis will clear up. Your fingernails will grow long and strong. Your taste buds will tingle. Your hearing will become more acute. You can throw away that old hearing aid. Your eyesight will sharpen. Your dandruff will cease if you have any hair. And if you do not have hair, it will grow hair. and your teeth will whiten, and your marriage will probably improve. Well, never mind what is in the bottle, Mr. and Mrs. America. Truth in labeling does not apply here. Truth in advertising has no place in this debate. Just swallow this magic elixir, and all will be well. The American people are usually good consumers. They are smart consumers. They read the labels on the grocery store shelf to get the fat content of the food they purchase. They read the labels on the cans of food that they buy. I know that I do. I want to find out how much fat there is in the contents, how much sodium, how much cholesterol, and how much by way of proteins and carbohydrates and so on. They look under the hood of cars that they buy. They kick the tires. They squeeze the cantaloupes and the cabbage heads and the other vegetables that they buy. They read the fine print. And by law, that fine print has to be placed on those labels. But I do not believe that the U.S. Senate is helping the people to exercise their prowess as good consumers with the debate so far on this floor. We are not discussing national priorities. We are not spelling out the contents of this snake oil amendment. We are not talking about what should or should not be on the chopping block for cuts. We are not debating the impact such an amendment might have on the economy. We are not talking about the hard choices that will have to be made by somebody if we enact this amendment.